lawsuit against NASCAR. Jeffrey KESSLER joins us. Mr. KESSLER, welcome aboard. Thank you.
Thank you for inviting me.
I will apologize for beginning our conversation at a fairly remedial level, but for the significant portion of our listeners and probably 100% of our hosts who are not fully fluent in legalese, what specifically are your clients alleging, and what constitutes antitrust in this case?
Sure. So this is an antitrust case. The antitrust laws are laws that regulate fair competition. One of the things the antitrust laws prohibit is somebody getting a monopoly, which means you're the only competitor, through unfair anti-competitive means. NASCAR is the poster child for being an illegal monopoly. It is, as all your fans know, the only premier stock car racing circuit in the country, maybe in the world. It got that position not by being the best or by investing money or by really, having the best thing out there that no one could compete with. No, it got there by acquiring its competitors, tying up the racetracks so no one else could form to compete with it, going to all the teams who are independent contractors and saying, you can't go race in anybody else's races, and imposing restrictions on the cars that the teams can't even take their next-gen car and put it in another race. So all of this gives them this monopoly power. And what do they do with that power? Well, they're not like some kind of like benign dictator monopolist. This is what they do. They go to the teams on September 6th, and they say to the teams, here is our take it or leave it offer to be a charter team in NASCAR. If you do not take it in the next hour, you are out. You will not get a charter. We might even get rid of the charters. We will destroy the whole economics of your organization. So what happens? 13 of the 15 race teams could not take that pressure. They said, well, if the alternative is this bully is going to crush me, if I don't say yes, I guess I'm saying yes. Two teams had the ability, the fortitude, the resources to say, I am not going to take this anymore. Someone has got to hold NASCAR to the same laws that apply to all other businesses. So that was 2311 and Front Row. They hired me, and that's why we filed this case.
Does the fact that this sport has been run by a single family for 3 generations in and of itself constitute a violation of antitrust law?
Not by itself, but it is the motivating factor for why it's been run this way. Because when you look at it, what the France family has done, they run it as if it's like their own personal fiefdom, where all the revenues and all the profits and all these big TV deals and money should mostly go to them. And what they offer to the teams, who, by the way, also pay the drivers, okay? So it's the teams and the drivers end up getting just enough economic scraps that they can barely survive, and a lot of them can't survive. In 2016, of the 19 owners, I believe, that existed then, I think it was 19, says 11 of them don't exist anymore because they couldn't survive under this system. Something has got to change. If the teams are going to invest in this sport, if the teams are going to make a better product for the fans, if the teams are going to survive long term, they have to be able to have a fair chance, if they're successful, to get some kind of fair return for their investment. This sport does not permit that because the France family runs this monopoly to stifle it. That's what has to change.
You said a moment ago, and it's also stated in your filing, that NASCAR's success has not been created by the superior product or skill of NASCAR's owners, but from anti-competitive and exclusionary practices. Is it truly your position that the sanctioning body has done nothing right to build the sport in the last 75 years?
No, I'm not saying they've done nothing right. I'm saying the way they have stopped the competitive process is through anti-competitive behavior. Nobody knows if stock car racing would be better, if stock car racing would be more innovative, if it would be more accessible to the fans, if it would be available at lower prices to the fans, if there was the breadth of competition allowed to come in. And what they have done is stifle all that competition. So we will never know in that world what it would have looked like. Going forward, we're going to see what competition can produce. What we know is in other sports, when competition has been introduced, it has gotten better for everyone. There's been more product. There's been better product. There's been less expensive product. All of that happens when you let the fresh air of competition come in the door.
A few moments ago, you characterized or claimed that some of the other owners were threatened or pressured or cajoled and just didn't dare to fight, couldn't afford to fight. We spoke to a number of the other owners in this sport in the days following the signing of the charter agreement and asked them specifically that question, and they replied that no, they did not feel threatened, they did not feel pressured, but after more than 2 years of negotiation felt that they had reached the best deal that they were going to be able to reach. How is your interpretation of their comments different?
My interpretation is, have you ever heard of the battered spouse syndrome? Okay, you will have someone who gets beaten, who gets abused, who stays in the relationship, and when the police show up to ask about it, they say, "Oh, it's okay. It's not so bad. I can keep living. I can survive."
Mr. Kessler, we're talking about Roger Penske. We're talking about Rick Hendrick. We're talking about Coach Joe Gibbs. We're talking about independently wealthy, wildly successful businessmen that are not renowned for getting pushed around.
All right. So I have spoken to some of those people. I'm not going to tell you who. Okay? And what they say publicly is not what they say privately. Okay? Here's what you might go back to ask them. How much profits did they make last year? How much did they make the year before that? How much do they think they'll make next year? See what they say, if they say anything.
2311, Denny Hamlin, Michael Jordan and company. Yeah. They joined this sport 4 years ago under the charter agreement that's currently in place.
Yes.
Michael Jordan said at the time that the advent of the Gen 7 race car created a more favorable business environment that convinced him to become involved as an owner where he had not seen himself clear to do so since then. Since then, they've invested tens of millions of dollars in their team, built a brand new state-of-the-art race shop. What has changed since Michael Jordan's previous comments about the favorability of the business model?
So Michael Jordan believes in NASCAR. He thinks it's a great sport. He has been a fan of NASCAR for decades, and he wants to be a part of it and helping it bring it into the 21st century. What's changed is, he couldn't possibly foresee how unreasonable the France family and NASCAR were going to be when it came time to renew these charters. He believed, like many people believe, that they were finally, some progress had been made with the 2016 charters, and that going forward, progress will continue to be made. Instead, the 2025 charters, when you look at it as a whole package, are worse than the 2016 charters. So it's not going forward, it's going backwards. And that has totally changed his view. He didn't expect that when he came in this sport, he would get an agreement sent to them at 5 o'clock on September 6th and say, sign it in an hour, you're not going to have a charter.
In what ways do you see the 2025 charter agreement as being worse than the current one?
There are innumerable ways. To give you one, it takes all the intellectual property of the teams, lets NASCAR use it itself without any obligation to share any of the value of that money back with the teams. Okay? It puts forward an economic system where NASCAR could increase the cost of the teams at its will to any degree, and the teams don't get to say anything. You just have to pay it, right? It's like when someone in a legislature, let's say Congress passes a bill and says, yeah, we're going to require this, and the states are going to go pay it. So NASCAR sets up a system that says, yeah, we're going to say you got to do all these things, and by the way, you pay for the whole thing. We're not going to pay a nickel, because that's not how we run NASCAR. I mean, I can go on and on, as to what's wrong with this deal, but what's really wrong is that it's illegal. It's illegal to get a monopoly this way and dictate terms so that no one else can get a fair return on their investment. And that hurts not just the teams, it hurts the drivers, it hurts the fans, it hurts the game.
Your suit asks for treble damages. What specific monetary damages have your clients suffered, and what's the amount that you'll seek in terms of reparations?
So we have not calculated that yet. It'll be based on an expert analysis. Triple damages are automatically awarded under the antitrust laws if we prevail. But we're talking a large sum of money. I don't have it calculated yet. We're not, we're going to certainly be talking about tens and tens of millions of dollars for each of these clients. But the more important part of this case is not the money. France Fielding has plenty of money. They could write a check. What the real point of this case is to get injunctive relief that's going to change the way NASCAR operates so that it becomes a system that's fair to everyone. That's the real hammer that's in this case. That's what's really going to change in sport for the teams, the drivers, and the fans.
Mr. Kessler, you either have filed or will soon, and I apologize for not knowing specifically, an injunction that will allow 2311 and Front Row to operate under the new charter agreement, the 2025 and beyond charter agreement, despite their refusal to actually sign that agreement. My question to you is, why would they want to be a part of an agreement that they have called unfair and injurious at its basis?
Sure. So they want to compete in NASCAR, right? They don't want to close their teams, right? The 25 charter agreement has a provision in it that says if you want to go forward with this charter, you should give up your rights to bring a lawsuit to assert your antitrust rights, okay? That itself is an antitrust violation designed to protect this monopoly. So what we're seeking in our relief is saying they'll sign the 2025 agreements because they want to compete. They want to be there, and they'll sue. It may take a year, it may take 2 years to get to trial, but they can't have as a cost that they give up their antitrust rights. So if we don't get that injunction, they will compete as open teams. But you cannot compete as open teams for very long. Right? You could start competing that way, but because as bad as the economics are for the charters, okay, you're talking about access to making tens of millions of dollars less if you try to compete open. The system is not designed to make open competition a long-term viable way of competing. That's why you see so few open teams these days. In the past, it used to be very different.
Is that your best estimate on the timeline that it might take to bring this to conclusion, 2 to 3 years?
No, I said 1 to 2 years.
Okay. All right. Is that likely? The likely scenario?
1 to 2 years to get to trial. That's what we're thinking. Obviously, the judge will set that, but that's our hope.
How do the parties coexist, in your opinion, in the coming months or years under the circumstances that exist now?
So I've done this in a lot of sports, and the answer is we expect both sides will continue to do business while they're in lawsuits together. I've represented, for example, the NFL players and the union who stopped being a union for 3.5 years while they were in antitrust litigation and did not have a collective bargaining agreement, and they just had to get along and keep doing their jobs. That's what we expect people will do here. There are a lot of companies out there who've had cases where they've had employees sue them, but the employee still works for the company. You got to do your job and go forward.
You've offered a number of examples of things that you think NASCAR needs to do differently or change. Are your clients willing to compromise on their wants and requirements and demands? And if so, in what areas?
So here's what I'd say. Front Row and 2311 did not bring this case to take like a D+ deal and settle for like a D deal. This changes have to be significant and transformative. They are willing to sit down in a settlement talk with NASA and work out what that is. Okay, so there could be compromise, but it has to be fair to both sides. I just did this in college sports. I was one of the 2 prime negotiators for the classes of athletes that have created the new system that hopefully is a go forward in college sports. That system is a compromise, but it is fair to everyone. That's the type of change that would have to happen here.
I guess bottom line on all of this, do you see that this is a formative moment in the history of the sport? Obviously, your clients are walking into this with the desire to make a radically different or to create a radically different form of this sport in the next year to 2.
I wouldn't call it radical. I think it will be transformative. I think a system will come out of this either by agreement or by court order that provides the ability for all the shareholders in this sport, all the stakeholders, to make a fair return. It will lead to more investment in the sport. It will lead to better competitions. It will lead to a greater product for sponsors, broadcasters, fans, drivers, and the whole community. That has been the experience of every sport in this country in which antitrust laws have eventually been applied.
I appreciate your time very